Welcome to our Shorthand Lab channel, Legal Dictation at the speed of 100 to 110 words per minute. So be ready. Start. This court has, in various decisions, applied the principle of equal pay for equal work and has laid down the parameters for the application of that principle. The decisions are rested on the concept of equality enshrined in our Constitution in the light of the directive principles in that behalf. But the acceptance of that principle cannot lead to a position where the court could direct that appointments made without following the due procedure established by law be deemed permanent or issue directions to treat them as permanent. The power to make an order as is necessary for doing complete justice in any cause or matter pending before this court would not normally be used for giving the go-by to the procedure established by law in the matter of public employment. Take the situation arising in the cases before us from the state of Karnataka. Keeping in view the aforementioned two principles in mind, we are of the opinion that in a case of this nature, a balance has to be struck. In the peculiar fact of the present case, despite the law operating in the field as noticed, supra, appellant might have been recruited as a casual employee, but the fact that he was brought on the rolls of a regular cadre is not in dispute. The fact that he had passed a trade test is also not in dispute. It furthermore stands admitted that as an ex-cadre employee or otherwise, he was promoted twice. He had been holding the said post for a period of more than 12 years. A policy decision was taken by the Railway Administration only on or about 15/10/2001. Prior thereto, there was no requirement to repatriate an employee to his parent cadre after a period of 4 years. The policy decision furthermore was not given immediate effect. Despite the said policy decision, the appellant was permitted to work for another 2 years. Faced with the situation, the learned additional Solicitor General submitted that the question in regard to protection of pay of the appellant would be considered by an appropriate authority if a representation is filed in that behalf. Keeping in view the lapse of time, we are of the opinion that in this case we should ourselves make an endeavor to strike a balance. In our opinion, it is a fit case where this court should exercise its jurisdiction under Article 142 of the Constitution of India to do complete justice to the parties. We think that while upholding the validity of the order dated 7/4/2003, interest of justice would be met if the pay of the appellant is protected in the scale of pay of rupees 4,500 to 7,500 to be fitted in the post of technician grade 3rd, for which the scale of pay is rupees 3,050 to 7,000. By doing so, we would not be violating any law or perpetrating any illegality. This appeal is allowed to the aforementioned extent. However, in the facts and circumstances of this case, there shall be no order as to costs. Thank you so much.